Morning, everyone, and welcome. I'm Louise Reid, Managing Director of CML, and thank you for joining us for our third Ask Me Anything webinar on Cayman immigration updates. We've received some really good feedback from the last two, so thank you very much for those. As we wanted to continue creating a space to talk through the changes we know many individuals and employers are still trying to get their heads around. Today's session is focused on residency, permanent residence, naturalisation and status-related changes. And as always, I'm joined by the wonderful Juliet Gilbert, who many of you already know from her work supporting clients through Cayman's immigration processes every day. Well, not every day, you get some weekends off, right? Juliet is going to take us through the key practical points, and my role really is to keep the conversation flowing, pull out the things our clients are most likely to be asking, and make sure we cover the areas that matter the most. As with our previous AMA sessions, this is designed to be a practical discussion rather than a formal presentation, although this particular topic is extremely detailed, so please do excuse Jules and I if we do have to look at our notes now and again on this one. We just want to make sure we get this right for you all. Please feel free to post questions in the Q&A chat box. I will do my best to keep an eye on it and to address them as they come in. But if we don't get to every question live, don't worry, we'll review them at the end and we will contact you directly. So just a quick reminder, but an important one before we start. Today's session is guidance, general guidance only. So, immigration is always very detailed, especially residency, but it really does matter on your individual history and your particular detail. So please do bear that in mind. So with that in mind, Juliet, before we get into the very specifics of this area, can you start by setting the scene for us? At a high level, what are the most important things people should understand about residence, PR, and that long-term immigration planning?
Yeah, absolutely. So at a high level, the key message is that immigration planning has become more important than ever. So while many of the core pathways remain in place, individuals do need to understand how the recent changes may affect their circumstances and long-term plans.
So do the changes affect everyone in the same way?
No, so it really does depend on the individual. So different rules, timelines, costs, and obligations are going to apply depending on, lots of different factors, such as, when did you arrive in Cayman? How long have you been resident? What are your family circumstances and whether you already hold PR? So people can no longer assume that, what might have applied to a colleague, a family member, a friend, is going to apply to them today.
Yeah, so even if the core rules weren't changed, you still need to know how the practical position will affect you personally.
Yeah.
Okay, so with that in mind, let's turn to one of the areas that's actually created quite a lot of confusion, which is term limits. At a practical level, have those term limit rules actually changed?
So for most work permit holders, no. So the 9-year term limit remains in place and individuals can still apply for PR in their 8th year of ordinary residence.
So we've had lots of calls about this over the last few months. So where do you think the confusion's coming from?
Yeah, I think it's partly because there were changes affecting certain non-Caymanian civil servants, which have received a lot of attention. So some people assumed those changes applied much more broadly, but for most private sector employees, the 9-year term limit remains.
It's the same. I think for me personally, I think that confusion, there was so much discussion and chat about term limits way before the reforms. I think people understandably just assumed something had changed, but actually, in fact, it hasn't for most people.
Yeah.
So staying with term limits, if someone is planning to apply for PR through the points system, when should they start getting ready?
So I would encourage people to start preparing well before their 8th year. People pursuing PR through the point system can apply once they've reached their 8th year on island, and they should ensure that their application is submitted before they reach their 9-year term limit. But not only does gathering the required documentation take time, we know that PR point system changes are coming later on this year. So we don't know when this is going to take effect or what changes are going to be made applicable. But individuals who are approaching eligibility should be thinking about this earlier than later.
Yeah, I mean, you say earlier, like, what does starting early actually look like? What would you suggest?
Yeah, I mean, honestly, the best place to start is really by speaking to an immigration professional who can look at your particular circumstances, the dates where you are in the process, your family, etc. Because that's going to tell you how it makes sense, what to do next. So at CML, we do PR consultations for individuals who want to understand the process and where they fit in the process. And if you're an organization, we can also come in and do a presentation for your staff and employees,
yeah.
to let you know what the process looks like and answer any questions as they come up.
Yeah, that's a great perk, because I suppose that would also wrap in the people who maybe are thinking really far ahead to go to one of those presentations. Okay, so staying with that theme of planning ahead, another area people are asking about is the removal of Section 6610, which I know we've spoken to in previous AMAs. In practical term, what does that mean for couples who may previously have been relying on that provision?
Yeah, so in simple terms, Section 6610 was a provision that in certain circumstances allowed one spouse to remain in Cayman based on the other spouse's remaining time under the term limit system. That has been removed as of the 1st of May. As a result, couples who may previously relied on that now need to look at alternative immigration provisions to stay on island. So again, you need to start planning much earlier than you would have ever before. And there is a limited exemption for certain spouses of UK government employees, but for the vast majority of people, that Section 6610 has been removed.
Yeah, it's really one of those areas where people need to be reviewing their position sooner rather than later, because they need to make decisions. Right? And so from my point of view, so anybody who's a couple on a work permit, especially if you've arrived at different times, this is a prompt now to look at your dates.
Absolutely, yeah. Yeah, this is one of the changes that will have a significant impact on long-term planning. So again, affected couples should understand their options as early as possible.
Yeah, absolutely. So that brings us on to one of, I suppose, the most important practical questions in all of this, and that's grandfathering. Never thought I'd say that word as many times as I have this year. But in simple terms, who is still protected by the old rules, and why does that matter so much?
Yeah, again, most of this information will be on the slide in greater detail. But if you've already held PR on or before the 1st of May 2026, or if you submitted your PR application before that date, you remain protected under the previous pathway to the right to be Caymanian. So that protection applies even if your application is still processing and has not yet been approved. So on the other hand, individuals that are submitting PR applications after that date are going to be under the new timelines under the Cayman Protection Act.
Okay, so really the date of the PR application that it was submitted can really have a major impact on your long-term immigration pathway.
Absolutely.
And so just to make that practical in my mind as well, and for those listening, so if someone already holds PR or applied for PR before May the 1st, what does that mean for their route to status?
Yeah, so if you already held PR on or before the 1st of May, or you submitted your PR application before that date, you do remain under the old pathway to status. So even if your PR is still being processed. So what that means is you can continue to become eligible for the right to be Caymanian after 15 years of residence, assuming all requirements have been met and following naturalisation. By contrast, anyone who submitted a PR application after the 1st of May is going to be under the new timelines for the right to be Caymanian, and generally linked to a longer period of residence following naturalisation. And so therefore, whether or not you are a grandfather does make quite a significant difference. Yeah,
so the key point here is find out which side of the line you sit on, because that's going to really change things.
Absolutely.
Okay, so another point that often catches people out is that permanent residence is not actually the final step before status. Can you talk us through where naturalisation fits into that pathway?
Absolutely, yeah. So yeah, one of the most common misconceptions is that PR automatically grants you the right to be Caymanian, but there is an important step between, and that is naturalization. So for permanent resident, the pathway remains largely unchanged. You hold PR for a period of 12 months and you can apply to be naturalized as a BOTC of the Cayman Islands, provided that you meet the requirements. But where we have seen a significant change is for the spouses of the permanent resident. So the route to naturalization for a spouse holding an RERC as a spouse of a permanent resident is now considerably longer and involves additional stages before they can become eligible, as per the slides.
Yeah, I think that's where people might actually be quite surprised, because the spouse's route now looks very, very different to that of the actual permanent resident.
Yeah.
How much longer are we actually talking about? What does that look like?
So under the new legislation, a spouse of a permanent resident or a Caymanian now has to hold their residence, their RERC, for 15 years. And then they have to obtain an indefinite renewal of that certificate, hold that for another year, and then apply to be naturalized. You can see that on the slides there. So whilst the pathway to the PR, the permanent resident, what largely remains unchanged, it's the spouse that is going to be significantly longer, their pathway.
Okay, so practical takeaway, people need to think beyond permanent residence. It's the long-term goal is status. They need to really think about that. And they also need to understand that naturalization stage looks like for them in their own circumstances.
Absolutely.
Okay. And for people who are not protected by grandfathering, is the practical reality that this is going to take a lot longer than they're probably expecting?
Yeah, generally that is the case. So for those who are not protected by the grandfathering provisions, eligibility for the right to be Caymanian will generally arise after 20 years of residence, or 10 years after naturalization, obviously, depending on your circumstances. And that's why determining whether you're grandfathered is really important here. So two people may appear to have very similar circumstances, but their timelines can be very different, depending on when PR was applied for or obtained.
Yeah. So it comes back to basically understanding which rules apply to you.
Yeah, absolutely. Yeah, that's why we're encouraging people to review your position very early on, and make sure that you understand your long-term immigration pathway.
Yeah, I think that's actually a really important point, because we do see a lot of confusion in all areas of immigration, but particularly this point, and it comes from people comparing their situation to someone else's, whether, it's the timing. Everything can be very different depending on your particular circumstance, right? So another area families often ask about is children. We actually had a question come through on that. So I'm going to ask something a little bit more specific, if that's okay, Jules. If a child is born to a permanent residence holder, what should parents understand about the possible pathway there?
Yeah, so the first thing to understand is that the pathway can vary depending on the child's circumstances, but there are some important things that parents should know. So when a child is born in the Cayman Islands to a parent who already holds PR, that child can be eligible to hold or apply for a BOTC passport at a very early stage. Beyond to that, the route to becoming Caymanian is going to rely on the family's personal circumstances. So a child may be eligible for acknowledgement of the right to be Caymanian, and then the continuation of that grant. Once the parent obtains status, then there could be the eligibility to apply to be Caymanian through the naturalization pathway. So in practice, we would look at all available options and identify which route is likely going to apply to the child. And again, the key message is don't wait. Children's immigration nationality options can be really fact specific, and that's where early planning here is often creates more opportunities.
Yeah, absolutely. I think this again another area where there's a lot more than one possibility.
Yeah.
The right answer really depends on the child's circumstances and that wider family network as well.
Yeah.
So staying on the practical side of planning, we're also getting a lot of questions, understandably, about cost. What are the main fee increases that people should be aware of?
Yeah, so the slide we'll talk about this as well, but the headline is that obviously immigration's become more expensive. So as you'll see from the figures on the screen, we've seen significant increases across PR, naturalization, and status applications. We've also seen the introduction of new annual fees and in some cases ongoing dependent fees. So the key message here is that people should no longer think of immigration as a one-off application cost, and it's important to understand the cost of the entire journey, and all of the expenses that you can think about in the long-term planning.
Yeah, absolutely. So the practical takeaway here is review the updated fee structure early and make sure there are no surprises further down the road.
Exactly.
Yeah, okay. So one of the less obvious changes is the annual fee position for certain permanent residents with the right to work. Can you explain what appears to have changed there?
Yeah, so this is a change that many permanent residents working in the special economic zone may not yet be aware of. So historically, permanent residents with the right to work in the zone paid a fixed annual fee, but under the new legislation, as you'll see, it appears that the annual fee is going to be linked with the actual role in the regulations, which would normally apply to that role. So the practical effect is where some individuals may only see a modest increase, most are going to see quite a significant hike, particularly those in senior or higher fee occupations than they would have paid historically. So this does remain an area that practitioners are closely, watching, but based on the legislation as currently drafted, don't assume that your annual fees are going to remain the same as they were.
Yeah, that's a big change. So permanent residents working in the special economic zone or the CEC, this is something they really need to look at carefully because, as you say, depending on occupation, it could be quite a significant change for them.
Absolutely.
Okay, so we are also seeing any grandfathering on those annual fees for people who obtain permanent residence before May 2026, or is that still unclear?
Yeah, so based on the legislation as currently drafted, there does not appear to be any grandfathering based on the annual fee structure. So what we have seen with grandfathering is in relation to certain applications and pathways. The revised annual fees appear to apply going forward, regardless of when you obtained PR.
Okay, but just to be clear, we have seen some fee protection for applications that were already submitted.
Yeah, so where certain applications were submitted before the changes came into effect, the previous approval fee structure may still apply. So, but that's separate from ongoing annual fee obligations. And so, whilst there are transitional provisions in the legislation, people shouldn't assume that those are going to apply to future annual fees.
Okay, and that's an important distinction because some protections do apply to earlier applications, but shouldn't assume, as you say, that there'll be future annual fees. Okay, so staying with that theme of ongoing costs, can we also touch on dependent fees for families? This is like really important practical issue, obviously. What's changed? What should they now budget for on an ongoing basis?
Yeah, so we've put some of the fees up on the slide, but one of the biggest changes for families is the introduction of ongoing dependent fees for PR holders. So whilst the cost of adding a dependent to a PR application is unchanged, what will be payable is annual dependent fees upon the grant of the PR application. So these fees apply to dependent spouses and children, and they are separate from any annual declaration fees that may also be payable.
Okay, so the numbers on the screen there, it's important to remember they're not one-off costs, they are annual costs, right? Okay.
Yeah, so for some families, particularly with multiple dependents, those costs are going to add up over time. So again, it's just important to factor them into your long-term immigration plans.
Yeah, it's a real practical point, isn't it, for families? You should be budgeting not only for the initial costs, which I suppose we do now, but also those ongoing annual costs for all the dependents.
Yeah.
Okay. So going a little bit beyond cost, there are now annual declaration requirements that people may not be aware of. Who especially needs to be careful of these new compliance obligations?
Yeah, so that is another really important change introduced by the new legislation. So certain categories of individuals that you'll see up on the screen there, including permanent residents, some spouses, are now required to submit annual declarations along with filing fees. So the key point is that these are annual ongoing obligations. So obtaining permanent residence or another immigration permission is no longer necessarily the end of the process. So in some cases, there are annual compliance needs that have to be met.
Okay, so whilst the filing fees themselves might not be particularly big, it's about the real issue is about not missing those deadlines.
Yeah, absolutely. So people should understand what obligations apply to them. So you need to diarize the deadlines and ensure that you remain compliant. the consequences of failing this to meet immigration requirements. So they're a lot more consequential than the filing itself.
Yeah. Seeing a theme here on the planning, but it's really about building this annual compliance into your long-term immigration planning. Right. So can we break that down a little bit further for spouses of Caymanians, particularly those with RERC, and for people who obtain status through marriage?
Yeah, so this is one of the changes introduced by the new legislation, is that certain spouses that hold RERC as a spouse of a Caymanian or status via marriage are now subject to annual declarations and filing obligations. So this is for a specific time period, and the key point is the individual you should understand that your longer term objectives, what they are and what steps that you will need to go to if you ultimately want to apply for the right to be Caymanian.
So holding an RERC as a spouse of a Caymanian and obtaining the right to be Caymanian through marriage are related, but they're not the same thing.
Yeah, exactly. So, and understanding where you are in that process is really important, particularly now that there are these compliance obligations for certain, individuals holding those permissions.
Okay. And before we move on to the last parts, let's talk about timing. We always get lots of calls about this, of course. What processing times and what are they currently looking like for permanent residency, naturalisation status, etc.?
Yep, so we've got these up on the slide here. So processing times can vary, but obviously based on current experience, we're seeing around 10 to 12 months for PR applications, about 11 months for status, and naturalisation is upwards of 12 months. So obviously individual cases can move faster or slower depending on your circumstances. But the key thing is, again, is that you need to think about these timelines if you're looking at the full organic picture. So if you're planning on a long-term pathway to, PR naturalization, ultimately status, that journey is going to take a considerably long time.
Yeah, that's a really useful point, because I think people often focus on a single application or the one they've got in now, but when all these stages add together now, it's, overall it's an immigration journey, shall we call it?
Yeah.
But it'll be a lot longer than a lot of people expect. So something to bear in mind.
Yeah, that's right. And that is why planning ahead is so important.
Yeah. So if someone is listening today and thinking, I'm actually not really sure which category I fall into anymore, which is understandable, what would your advice be on the first steps?
The first thing I would say is you're not alone. So the key to understand, what is your current immigration position? How long have you been resident? Have you already obtained or applied for PR, and whether any of the grandfathering provisions may apply to you? So, we would also want to understand your family circumstances, your long-term goals, because those factors are going to have a significant, impact on what options are available to you.
Yeah.
One thing I would caution against is assuming that what applies to a friend, family member, colleague automatically applies to you. So especially now with small differences in immigration history, timing can lead to, very different outcomes. So if you are genuinely unsure where you fit, I would say seek professional advice, because that can provide clarity really quickly, and you can understand your options, timelines, and important deadlines.
Yeah, and that could be you.
Exactly.
But yes, I understand that. That's great. And I think, as you say, it's understanding your position. And that's really, everything we're talking about today seems to be, that's the foundation of what you need to do. Know which rules apply to you and plan your next steps with confidence.
Yeah.
Right. So from an employer's perspective, or even, I suppose, like a family planning perspective, what should people be doing now rather than waiting until there's a deadline, or, as quite happens quite often, a problem?
Yeah. So the simple answer is plan early. So for employers, now would be a good time to identify your employees who may be approaching key milestones, such as eligibility for PR, and ensure that they understand the options that are available to them. So for individuals and families, it's important to understand whether grandfathering applies, what your pathway is to PR naturalization and status, what costs are available, and ongoing obligations that you might have to do along the way. So it's also worth looking at the bigger picture. So your annual declarations, your processing times, dependent fees, family circumstances, and the people that have the smoothest immigration journey are the ones that plan ahead.
Yeah, I think that don't wait until action is urgent. Understanding your position early not only gives you more time, obviously, but it also gives you more options quite often.
Yeah.
I think looking down now, we covered most of the questions that have come through. So I'm going to ask you one last thing, I think. What would you say are the 2 or 3 biggest mistakes or misunderstandings that you'd like people to avoid?
So if I had to narrow it down to, 3 things, I'd say, firstly, don't assume that the term limit rules have changed. For most private sector employees, the 9-year term limit remains in place, and people should continue planning accordingly. Secondly, don't assume that everyone is on the same immigration pathway. So whether grandfathering applies when PR was obtained or applied for, and individual family circumstances are all going to make a significant difference. And then thirdly, don't wait until the last minute. So whether it's PR, naturalisation status, family planning, fees, annual compliance obligations, people generally have got more options when they start planning early. So I would also add that we are only 6 weeks into this new legislative framework. So whilst this is in force, we do expect further guidance and clarification as these provisions, are implemented in practice. So ultimately, like we've said before, the biggest mistake is assuming that what applies to a friend, colleague, or family member automatically applies to you. The changes we've discussed, they're highly dependent on individual circumstances.
Yeah, I think everybody who's listening today will hear the themes here that are going through, and it's not that we want to repeat ourselves, but it is just the way it is. But you really need to know which rules apply to you. They need to be planning ahead, and don't leave those important immigration decisions until a deadline is approaching, because you will be out of options.
Yeah.
So thank you so much, Juliet, and thank you to everybody. That was really helpful, and hopefully it's given everyone listening a clearer understanding of what's changed, what remains unchanged, importantly, and what steps you may need to take based on your own circumstances. As I mentioned earlier, this is our 3rd AMA webinar, and as of today, we have covered the major changes that have been introduced by this new reform. We hope that these sessions have helped set, a complex set of changes to be a little bit easier to follow and apply in practice. But that said, if there are any topics that you would like the CML team to address, or you're just missing Jules and I on these webinars, let us know. We'd love that feedback. If you think it's a great future AMA, we'll certainly consider it and put it in. We want to make sure that you're getting the most out of your partnership with CML, and that these sessions continue to be useful, practical, and relevant. For anyone joining us live today, we are sharing a booking link in the chat, so that if you want to arrange a really quick call with Juliet just to ask any questions, you can do so. That's a hot commodity, straight into her diary. Even I don't have that. But of course, if you want to reach out to the team by email or phone as usual, that's absolutely fine too. Thank you again to everyone for joining us, and for those who submitted questions. It was so helpful. And after the first sessions, we did have a lot of people follow up looking for the recordings, which is a good sign, I suppose. But I just want to let you know that they do take a few days, because what we do is we do edit them with timestamps, so that when they come through, you can click and watch the bits that are relevant to you. So just give us a few days, and we will make sure that that comes out to you. But we really appreciate your engagement and support for the series so far, and we very much look forward to continuing the conversation with you all. Thank you so much, and thank you, Juliet.
Thanks.